some announcements. Okay, so welcome everyone. I know you all know who I am by now. Wendy Rosenberg, Vice President of South Florida Title Associates, the Nob Hill branch. As you know, I've been in the business probably close to 40 years now. I like to say I started when I was 12. So, if you have any questions about title, please feel free to reach out to me, because if I don't know the answer to your questions, I do know where to find the answer to your questions. I have a great team at South Florida Title Associates, the Nob Hill branch. We have bilingual processors and closers, and we can close on real estate that's located anywhere in the state of Florida. We work with RON closers, notary closers, remote closers. We can close short sales, refinances, commercial transactions, real estate located in Florida. We can close it for you. Our fees are super reasonable. Our settlement fee is only $6.85 to the buyer, $6.85 to the seller. We don't have junk fees. We don't charge extra for notaries. The only time we charge extra is if you have multiple out of the office notaries, or if you have, hold on, sorry, I'm letting people in. Multiple out of the office notaries, or if it's a RON notary. Wait, I'm hearing somebody. Please put yourself on mute, okay? Please, everybody mute yourselves. Okay, so I've got a great meeting here. If you have any questions, like I said, put them in the chat. Do all these training classes to build a relationship with you, the realtors, and I hope that you get great, useful information. And when you need a title company, you think of me, Wendy Rosenberg, South Florida Title Associates, the Nob Hill branch. This is my give back to you. I do all these great trainings for you in hopes that when you have a deal for title, you send it to me. And I'd love to work with you. I always say working with me is concierge service. If you need anything along the way, or your buyers or sellers need anything along the way, you can feel free to text me, call me, email me. You have my cell. I do answer it, even if it's nights and weekends, as much as possible. But I am here to help. I want to make sure that you're happy and your clients are happy, because we all work on referrals. Just like you work on referrals, I work on referrals. We all need happy customers, clients. So that's the name of the game. Okay, so think of me on your next contract. Wendy Rosenberg, South Florida Title Associates, the Nob Hill branch. Okay, go ahead, Alexander. Take it away.
All right. Well, thank you for attending, everybody. I am Alexander Johnson. I'm a real estate attorney. I've been practicing law for 37 years. My office is in Fort Lauderdale, Florida. Although it seems like ever since COVID, it doesn't really matter where your office is. Everything is closing remote and closing in escrow. So now when I get an eviction, you just email me your paperwork. I'll email you back your retainer agreement. People pay the funds electronically. I find that Zelle is a real godsend for sending and receiving payments. So you can do your entire case without us ever meeting each other, or you having to do anything except meet the sheriff at the property at the end of the case. So it's very efficient. I remember when I first started, before there was internet, we would have to walk over to City Hall to do title searches by reviewing microfilms, and go to the water department to get the water bill. So it's so much more streamlined. So today I'm going to discuss landlord-tenant law, and as always, we're going to discuss the new changes to the law, because after many decades of landlord-tenant law being unchanged, they seem to be changing it a lot recently. So there was a change that took place this year, and it's going to kick in October 1st, but good to know about it in advance. So that is going to be the fraudulent entry of residential buildings law. The other topics I'm going to address is move-in and move-out fees, lease extension versus lease renewal, pet addendums, what is a service animal, and what is an emotional support animal. I do get a lot of calls about people who moved in with no dog, and all of a sudden they have a dog, and then they've got some certificate they downloaded off the internet, and it's an emotional support animal. And most of the time that seems pretty shady. And I'll tell you what the rules are so you can stay out of trouble and give good advice to your landlord clients. After that, if we have time, I'll discuss the forms that normally you're called upon to use in property management, which would be the 3-day notice to pay rent, the 7-day notice to cure lease violation, the 30-day notice of non-renewal. I'll touch upon security deposits, and Wendy asked me to say a few words about Section 8. So with that, let's go with the fraudulent entry of residential building law. This starts October 1st, so the law has passed, so it's going to happen. And this is Florida Statute 817.537. And it states that any person making a false statement in writing in any rental application relating to the person's identity, impersonating another person, or presenting forged documents commits a third-degree felony and is also subject to an eviction for an uncurable lease violation, which is what you do when you provide the 7-day notice incurable. So that notice states you have violated the lease and the lease is terminated effective immediately, and you have 7 days to vacate. So I'm just going to read you the statute. It's not very long. Again, 817.537, and it states, a person may not enter into or take possession of a residential dwelling by knowingly and willfully, A, making or causing to be made any material false statement in writing relating to the person's identity in any rental application for residential tenancy. B, presenting forged, fictitious, or counterfeit documents to the landlord of a residential dwelling unit, including but not limited to a driver's license, identification card, bank statement, or pay stub. And C, executing a rental agreement or taking possession of a residential dwelling unit while impersonating the person in whose name the rental application is submitted to the landlord. A person who violates this section commits the offense of fraudulent entry of a residential dwelling unit, a felony of the 3rd degree. Then they amended the landlord-tenant statute 8356 to state, if a tenant materially fails to comply with 8352 or material provisions of the rental agreement, other than a failure to pay rent or reasonable rules or regulations, the landlord may, if such noncompliance is of a nature that the tenant should not be given an opportunity to cure it, or if the noncompliance constitutes a subsequent or continuing noncompliance within 12 months of a written warning by the landlord of a similar violation, deliver written notice to the tenant specifying the noncompliance and the landlord's intent to terminate the rental agreement by reason thereof. Examples of noncompliance which of the nature that the tenant should not be given an opportunity to cure include, but are not limited to, destruction, damage, or misuse of landlord's or other tenants' property by intentional act, an act of fraudulent entry of a residential dwelling unit, regardless of whether criminal proceedings have commenced or a subsequent or continued unreasonable disturbance. In such event, the landlord may terminate the rental agreement and the tenant shall have 7 days from the date the notice is delivered to vacate the premises. So when you're violating the lease, there's a 7-day notice that says notice of lease violation, and that comes in 2 flavors: curable, which is anything that violates a lease term, and that says you've violated the lease and you have 7 days to cease the violation. So that would be unauthorized occupant, unauthorized pet, parking in the grass, loud parties. So the landlord says you've done this and you have 7 days to stop it, or you're subject to eviction. And then there's the incurable violation, and that says you don't have a chance to cure it. I'm terminating the tenancy right now, and you have 7 days to get out. So heretofore, that really requires either serious property destruction or violence. So that means pulling a gun or a knife or a fist fight or a fire on purpose. So normally you don't see too many incurable violations, the 7-day notice. Normally the practice is to go with the curable violation. But I guess when they went to the trouble to pass this law, they said that lying on your application is serious enough that you're out. And also to make it a felony in the 3rd degree. So that's serious stuff. I don't have much faith that any state's attorney or police would take any action based on that, but I think by making it a felony, they're expressing the intent that this is serious. Okay, so the next subject is move-in fees and move-out fees. In Florida, there is really no regulation in this area. So the landlord is at liberty to do anything they want. So move-in fees and deposits. Application fees. There's not any real legal cap on what you charge for an application fee. And in my experience, I've seen application fees that are sort of reasonable in light of the labor involved in processing an application. And then with these new, BlackRock Wall Street landlords, you can see that they've turned the application fee into sort of a revenue stream with fees of many hundreds of dollars. So I'm not sure if I really feel that that's morally right to charge $500 for an application fee, but it's not regulated by Florida law, so it's at the landlord's discretion. Security deposit, same thing. Traditionally, it's a month's rent, but it's not regulated. In fact, they passed a law a couple of years ago offering an interesting alternative to a security deposit, which is a fee in lieu of security, in which the landlord offers to accept a non-refundable monthly or upfront fee instead of a security deposit. Now, this requires a signed separate written agreement. And here's what's interesting. The fee in lieu of security deposit is simply a fee. It's just like you raise the rent by that amount of money. And the money doesn't go towards any damage. So if the tenant did damage anything, they don't get a credit for all the security deposit fees they've been paying. They still can be sued for the damage they did. So that's something landlords could think about. But just as a general principle, I will tell you that deposits are considered the tenant's money held in escrow, meaning the deposit remains the tenant's property and they're entitled to get it back unless somebody has made a lawful claim against it. So that's escrow money. A fee is just a charge. So you can charge whatever fees you want, decorating fee, pet fee. A fee is just extra money that the tenant owes the landlord. That's not refundable under any circumstances. So just bear in mind, anything you write down and describe it as a deposit, that money has to be returned to the tenant. If it's written down as a fee, the money is never returned to the tenant. So if you want to charge for painting and recarpeting, don't get it from the security deposit because that's refundable money. Make it a decorating fee. Then that's just a charge. So that's up to you about how you want to deal with your overhead. But again, if you want to collect for things that are not normally a charge to the tenant, then make it a fee. And that is unrestricted by law. All right, late fees, again, no limit. You can charge any late fee you want. It's funny because sometimes I'll give AI a crack at answering a question. And AI stated late fees must be reasonable, but that's actually not true. Late fees have no restrictions except for one thing, which is you can't stack late fees. So for instance, if I didn't pay April rent, I would get a late fee. And then now it's May. The landlord can't give me a second late fee because I'm 2 months late. It's one late fee. However, a way around that is instead of having one late fee, have a daily late fee. So you could say the late fee is $50 a day. So to that extent, if I didn't pay April, I'd still be paying 50 a day all the way through May. But you can't charge a late fee for every month for that month's rent. So if I didn't pay April, one late fee for April, presumably I didn't pay May either, so I get a May late fee, but I don't get a second April late fee in May. So the amount is unrestricted, you just can't have them piling up on each other.
There are some questions in the chat.
Okay, go ahead.
I don't know what they all pertain to though. It says, what about a tenant that smokes and neighbors are complaining? What about a tenant that smokes pot and neighbors are complaining?
Well, that would have to be a lease violation. So the violation might be the nuisance of the smell. So that could be a violation of the lease. You might have no smoking in your lease, so that's a violation. So that would be addressed with the 7-day curable notice of lease violation. So bear in mind that in all cases, when you are going to evict a tenant, that's a lawsuit. You can't do anything on the street side. You can't do self-help. So whatever you're going to do to kick somebody out of their dwelling unit, you need to file a case in court and prove up your case. So with rent, that's easy to prove because really you just say they didn't pay the rent and then the tenant has to prove that they did. So the tenant is proving non-payment of rent. But with a lease violation like smoking pot, you would have to prove they were smoking pot in a courtroom. So how you do that, I don't know, like photographs, video, witness testimony. That's a lot harder to pull off. And a lot of times in reality, the other tenants will be complaining, I don't like the smell of the pot. But when it's time for the hearing, they don't want to testify, even if it's on Zoom. So if you're a landlord and you file a case, make sure you can prove the case.
And then there's a couple other questions. Did you say there's no legal fee cap for a private landlord or an HOA or either one or all?
Well, if you mean attorney's fees, landlord-tenant law does provide for the prevailing party to request that the losing party pay their attorney's fees. But in that effect, the attorney's fees are reasonable attorney's fees. So depending on the judge, every judge handles this a little differently. The formal way of doing it is you'd submit your timesheets and your billing rate, and then you would hire an expert witness to say that the amount of work you did was reasonable in the amount of hours, and also that your billing rate is a reasonable rate. And then there's some things you're not allowed to charge for, like administrative work. So then you have an evidentiary hearing where the lawyer asks for his fees and the other side tries to knock them down. But the standard is reasonable. So that's reasonable in the amount of time expended and also reasonable in the hourly rate. So as an example, there was a case I read where a law firm said, well, we're very meticulous. So we do everything twice to make sure there's no mistakes. And the judge goes, no, we're not going to give you double attorney's fees because you're so detail oriented, you do everything twice. So no, I'll give you one set of attorney's fees, but I'm not going to give you double. So that's where the judge says what I think is reasonable or not.
I'm going to let you keep going because there's a lot of questions, and I think we're not going to get through the material if we answer all the questions as we go. So we'll take them all at the end.
All right, fair enough. So the next subject is bounce check fee. That is regulated by state law, and effectively the bounce check fee is 5% of any check above $300. Okay, security deposit. This is a very tricky area for landlords because the statute says that in order to claim a security deposit, the landlord has to use a specific form and it has to be mailed by certified mail, postmarked no more than 30 days from the end of the tenancy. If the landlord doesn't use the right form or the landlord doesn't do certified mail, and not certified mail means anything that's not certified mail, meaning no FedEx, no USPS overnight, no UPS, no courier service. They're very strict. It must be certified mail. So if you don't do either of those two things, you can't keep the deposit. But like I said, it's escrow money, so that must be given back to the tenant. That doesn't mean you can't sue the tenant independently for the damage that they did, but you have to give back the security. And if you don't, the tenant can sue you. And if they sue you and the judge agrees that they're entitled to a refund, you will pay the tenant's attorney fee. And I take on these cases for tenants sometimes, and believe me, the fee can get pretty big. So if you're a landlord, you want to be really careful about keeping people's deposits because you can pay a big penalty. And again, the only limit is what the judge thinks is reasonable. The amount of the fee is not tied to the amount of the deposit. So you could keep a $100 deposit and pay a $5,000 attorney fee. They're not connected to each other. Okay. So what can you deduct for if you are making a claim? And that is any damage beyond normal wear and tear in light of the duration of the tenancy. So a 1-year tenancy would be a little wear and tear, and a 10-year tenancy would be a lot of wear and tear. Again, this is all at the judge's discretion as a finding of fact. As a general rule, I would say that cleaning and painting are not legitimate charges. But I've seen if the landlord has got some drastic photos that shows the place is really, really dirty, I've seen the judge award deductions for cleaning, even if it's just food left in the fridge and dog hair all over the place. If it looks bad in the picture, the landlord might just get away with it. But as a rule, you want to charge for breakage, and especially you want to charge for things that you have receipts for. That you say that they broke the toilet and you went to Home Depot and bought a new toilet and you have a receipt for it. But anything in the gray area, it could go either way. But what's not gray is that if the tenant gets any money, even $1, they're the prevailing party and they get 100% of their fees. So this is an area where landlords have got to really watch out. Normally, if you get a letter from an attorney and they're not already demanding an exorbitant fee, just go ahead and pay them to go away because it's too expensive. Because what's going to happen to you? You don't want to settle. So the case is going to go to mediation, and then it's going to go to trial. You're going to have trial prep. You're going to have trial time. You know, we're definitely in the $5,000 realm. And there's nothing you can do to turn off the spigot in the meantime. And by then, they've spent all those hours, and it's reasonable. So again, be careful. So here's another fee that you can do, early termination fee. So the law, and I had a hearing this morning where this was an issue. So the law says that you can charge up to 2 months rent for premature termination of the lease. So that's a tenant that leaves before the end of a written lease, or a tenant that walks out on a month-to-month without giving a 30-day notice. So this is not automatically provided by law. You have to have a written agreement. So that'll either be a standalone agreement for early termination, or if you look at your FAR lease, it's a little option that says I elect for early termination or I don't. So if you don't, you owe the rent as it comes due until the end of the lease. Or you can say, all right, I don't want to do that. I want to flat it out at 2 months rent. So then the landlord gets 2 months rent right off the bat. But if the place is vacant for 6 months, they don't get 6 months rent. They just get the 2. Okay. So again, anything that's a fee has to be part of a written agreement. The landlord-tenant statute, chapter 83, doesn't have any fees for anything. So if you want fees, you have to have something in writing establishing those fees. So that's the security deposit, that's late fees. Anything that's a fee, you need it in writing. Okay, lease extension versus lease renewal. So an extension means you're taking your existing lease and the only thing you're changing is the end date. So all the terms stay the same. Lease renewal means you're signing an entirely new contract. So when you're doing a new contract, you can change all of the terms. You're not stuck with any previous terms. So you can raise the rent, raise the deposits, anything you want. It's an entirely new deal. So when you have a written lease with an end date, it is presumed that when you get to the end date, that's the end of the relationship. Leases don't renew by themselves unless you added something about automatic renewal. So a lot of people will call and say, you know, when the lease is up at the end of May, what's going to happen? And I said, well, on June 1st, you're a trespasser. That's what's going to happen. So unless you and the landlord sign a new lease, there is no new lease. And you're not month to month either. You're a trespasser. So just bear it in mind that a lease with an end date ends when it says so, and that's the end of it. All right, pet addendums. So this is something that comes up a lot. A pet addendum is a legally binding document added to a residential lease that outlines rules, fees, and responsibilities for keeping pets on the property. Typically, it specifies the pet's breed, the size, it imposes liability for damage or noise, and it probably will incorporate some non-refundable fees or maybe a security deposit for the pet. Then again, there's no regulations putting a cap on any of that. All right, so what is the one thing about pets that is regulated? And that is this whole thing of service animals and emotional support animals. And this often gets people confused. So these are two distinctly separate categories of creatures. They're almost the opposite of each other because service animals perform a service and emotional support animals do not provide a service. So let's get into the nitty-gritty of it. Florida Statute 413.08, service animals, protects the rights of handicapped persons, defined as individuals with a disability, defined as a person who is deaf, hard of hearing, blind, visually impaired, or otherwise physically disabled. Hard of hearing means an individual has suffered a permanent hearing impairment that is severe enough to necessitate the use of amplification devices to discriminate speech, sounds, and verbal communication. Physically disabled means any person who has a physical impairment that substantially limits one or more major life activities. Any individual with a disability or a person with a guide dog / service animal is entitled to full and equal access to the rental property, with the exception of a single room in a single family home, without having to pay any fees for the dog. Customary pet deposits may not be collected. However, the tenant remains liable for any damage to the premises done by the dog. Service animal is defined as an animal that is trained to perform tasks for an individual with a disability. The task may include, but is not limited to, guiding a person who is visually impaired or blind, alerting a person who is deaf or hard of hearing, pulling a wheelchair, assisting with mobility or balance, alerting and protecting a person who is having a seizure, retrieving objects, performing other special tasks. A service animal is not a pet. All right, and then the Federal American Disabilities Act restricted service animals in 2010 to dogs only. So at one point, service animal was anything that could do a task, which could be a horse, even a rodent, So I don't know how a rodent could perform a task, but I suppose if it did. But anyway, under ADA, service animals are only dogs. All right, definitions. U.S. Code of Federal Regulations, 36104. A service animal means any dog that is individually trained to work or perform tasks for the benefit of an individual with a disability, including physical, sensory, psychiatric, intellectual, or a mental disability. Other species of animals, whether wild or domestic, trained or untrained, are not service animals for the purpose of this definition. The work or task performed by a service animal must be directly related to the handler's disability. The examples of work or tasks include, but are not limited to, assisting individuals who are blind or who have low vision with navigation and other tasks, alerting individuals who are deaf or hard of hearing to the presence of people or sounds, providing nonviolent protection or rescue work, pulling a wheelchair, assisting an individual during a seizure, alerting individuals to the presence of allergens, retrieving items such as medicine or retrieving the telephone, or providing physical support and assistance with balance and stability to individuals with mobility issues, and helping persons with psychiatric neurological disabilities by preventing or interrupting impulsive or destructive behaviors. All right, the crime deterrent effect of an animal or the provision of emotional support, well-being, comfort, or companionship do not constitute work or task for the purpose of this definition. So I think that's pretty clear. A service animal has to be trained. There will be proof of the training or certificate, and the training has to be directly related to the disability. So now we get into the very nebulous area of emotional support animals. And this is where it's tougher on landlords. So emotional support animals do not provide any training or perform any tasks. They do not require training. They do not perform tasks, provide assistance. They only provide therapeutic emotional support by virtue of their presence. So that is pretty loosey-goosey, in my opinion. All right, so what is the legal scenario? The tenant makes a reasonable accommodation request. So it is unlawful to discriminate in the provision of housing to a person with a disability or disability-related need for, and who has or at any time obtains an emotional support animal. So here's the problem for the landlord. A person with a disability or disability-related need must, upon the person's request and approval by a housing provider, be allowed to keep such animal in his or her dwelling as a reasonable accommodation in housing, and such person may not be required to pay extra compensation for such animals. Unless otherwise prohibited by federal law, a housing provider may A, deny a reasonable accommodation for a request for an emotional support animal if such animal poses a direct threat to the safety or health of others, or poses a direct threat of physical damage to the property of others, which threat cannot be reduced or eliminated by another reasonable accommodation. And B, if a person's disability is not readily apparent, the housing provider may request reliable information that reasonably supports that the person has a disability. Such information may include, 1, a determination of disability from a government agency. 2, receipt of disability benefits from a government agency. 3, proof of eligibility for housing assistance or housing voucher received because of a disability. So that's government proof of disability. All right. 4, information from a healthcare provider, a telehealth provider, or any similarly licensed or certified practitioner or provider in good standing with his or her profession's regulatory body in another state, but only if such out-of-state practitioner has provided in-person care or services to the tenant on at least one occasion. Such information is reliable if the practitioner or provider has personal knowledge of the person's disability and is acting within the scope of his or her practice to provide the supporting information. If a person's disability-related need for an emotional support animal is not readily apparent, the housing provider may request reliable information that reasonably supports the person's need for the particular emotional support animal. Such information may include 1, information identifying the particular assistance or therapeutic emotional support provided by the specific animal from a healthcare provider, telehealth provider, or a similarly licensed certified practitioner in good standing with his or her profession's regulatory body in another state. Such information is reliable if the practitioner or provider has personal knowledge of the person's disability and is acting within the scope of his or her practice to provide the supporting information. 2, information from any other source that the housing provider reasonably determines to be reliable in accordance with the Fair Housing Act. If a person requests to keep more than one emotional support animal, you may request information regarding the specific need for each animal and proof of compliance with state and local requirements for licensing and vaccinating each emotional support animal. And I'll just give you an aside that Dade County considers unvaccinated dogs the responsibility of the landlord. So if there is an unvaccinated dog at your property and you're the landlord, you can get a building code violation as the landlord. So they put the burden on the landlord for that. So in Dade, you've got to be extra careful that the pets are vaccinated or it goes to you. All right, limitations on requests. Notwithstanding the authority to request information, a housing provider may not request information that discloses the diagnosis or severity of a person's disability or any medical records relating to the disability. However, a person may disclose such information to the housing provider at their own discretion. A housing provider may develop and make available to persons a routine method for receiving and processing reasonable accommodation requests for emotional support animals. However, the housing provider may not require the use of a specific form or notarized statement or deny a request solely because the person did not follow the landlord's routine method. An emotional animal registration of any kind, including but not limited to an identification card, patch certificate, or similar registration obtained from the internet, is not by itself sufficient information to reliably establish a person has a disability or a disability-related emotional support animal. So as a practical matter, all those BS internet certificates are simply that, BS. So they count for nothing. What you really need is the doctor letter. And that is a doctor that has physically seen the tenant. So no internet letter from some fake doctor. A doctor that has seen the tenant in person. That is your information, nothing from the internet. And that should clear it up. But once you get the doctor letter, you're pretty much stuck because you can't dig into it and cross-examine them like, I don't believe that you have a disability, and frankly, they don't have to prove anything other than that having the pet makes them feel good, which I think is true of any pet under every circumstance. All right, the tenant with the ESA, emotional support animal, is still liable for any damage done to the premises or any other person done by the emotional support animal. Okay, again, emotional support animals and service animals are completely different. So all of the ESA rules do not pertain to service animals. And again, there's a couple of exemptions from having to put up with ESAs. One is a single room in a single family home. So you can ban emotional support animals. Also, you can ban them in a unit of 4 unit or less building. And in which case the owner has to have no more than 3 properties in their name. Otherwise, I guess you're considered, a commercial landlord. Okay, so that's the subjects that I told Wendy I would get to. So let's get to the questions.
There's a lot of questions. You might have answered some of them, and so I'll read them too if you want.
Sure.
Can you give a 7-day notice for not getting rent?
No, that's for breaking the rules. Not paying the rent is 3-day notice.
Does 7 days notice apply to tenant requesting for repairs and landlord does not want to address them? Can the tenant cancel her lease without penalty?
Good question. So when the tenant is the one giving the notice of noncompliance, then they have to specify what's wrong, and the landlord has to be given 7 days to address the issue. The landlord then has to make a reasonable effort to address the issue. The court acknowledges that some issues can't be solved in 7 days. They just have to make a reasonable effort. So at the end of the 7 days, if the landlord did make a reasonable effort, the landlord is not in breach of the lease. If, however, the landlord did not make a reasonable effort, the tenant is at a crossroads, and they can pick one of 2 remedies. And that depends on whether the property is habitable or not habitable. So habitable means you can live there. So if you are living there, it's habitable. You can't be living there and say it's not habitable, because by being there, you've proved yourself wrong. And this comes up a lot. I had a tenant that stayed for 8 more months while we litigated, claiming it was uninhabitable the whole time. And at the end of the case, the judge goes, well, tenant, you lived out your entire lease, therefore proving it was habitable. So I'm not refunding you any rent or reducing your rent in any way. So uninhabitable means you pack your bags and you leave. So then what happens? The landlord doesn't agree with you and they keep your last in security. So then you're going to have to sue them. And to show that you're entitled to your money back, you're making the case that the landlord is the one who is in breach of the lease. Therefore, your contract was terminated and you did not owe any additional rent or security. So it is habitable, meaning you are living there. Then what you do is you go on rent strike. So you don't pay any more rent until the landlord fixes the problem. So what's going to happen is the landlord is going to give you a 3-day notice and file an eviction for non-payment of rent. So unfortunately for the tenant, there's no other path. So you do get an eviction on your record, which is going to cause you problems. But so the landlord files the eviction for non-payment and you defend with your 7-day notice. Of course, for this all to work as a tenant, your 7-day notice must ripen before any 3-day notice from the landlord. So timing is very important. So let's say you issue the 7-day notice on the 2nd day of the month. So you're already 1 day late in the rent. The landlord says, hey, you're late in the rent. Here's a 3-day notice. So here's the problem. You have 3 days to pay the rent and you don't get to go on rent strike until 7 days. So if your notice didn't ripen first, you don't have a defense to non-payment. So a lot of times it's a race to the finish line. Whose notice ripens first? So on the assumption the tenant's notice ripened first, then they have a defense to non-payment. And when the landlord files the eviction, the tenant's going to file a motion for rent determination, stating, hey, judge, the landlord is in breach of the lease, they're not maintaining the property. I am not getting what I paid for. The enjoyment value of the unit is diminished. So let's say it was a 3-bedroom and because of a leak, one of the bedrooms isn't usable. So you say, Judge, I think you should reduce my rent by 1/3 because 1 out of 3 bedrooms is not usable. So the judge will hear the evidence and then make a decision, a finding of fact, as to how much the rent should be reduced. So the rent could be reduced to 0, or it could be reduced not at all. But the judge is going to issue a ruling about what they think the rent should be. And then the tenant will have between 1 day and 5 days to start paying that amount of money to the court registry. And once that happens, the case will go on until the landlord finishes the repairs. And the tenant will keep paying the rent to the court until the case is resolved. So at the end of all that, it may be that the tenancy is not terminated and the court may decide whether or not the tenant is the prevailing party and award the tenant attorney's fees. Typically, because the attorney's fees is discretionary, the judges tend not to award fees unless it's a very clear-cut victory. So if it's sort of like 50-50, the judge is not going to penalize one of the parties for not being the clear winner. You have to really be the fully prevailing party to get the attorney's fees. I see a comment about the fee in lieu of security. Yeah, it's a ripoff, but if you agree to it, you agree to it. Regarding paying the deposit in installments, again, deposits are escrowed monies. So if you didn't continue to pay the escrow, then that's not money you owe the landlord. That's you didn't pay your escrow. So what the landlord should have done is to give the tenant a 7-day notice to say, hey, our contract said you were supposed to make a security deposit and you didn't. So by virtue of that, you're breaking the lease. So when you inherit a lease from a previous landlord, which is what you do, because selling the property doesn't have any effect on the tenancy. So we're all in the field of real estate. So once you have conveyed something to somebody else, you don't have it anymore. So when a landlord rents to a tenant, they have conveyed the legal right of possession from the landlord to the tenant. So the landlord doesn't have the right of possession anymore, meaning the right to occupy the unit. They have given that to the tenant. So when you sell the property, you don't have possession to convey to your buyer. The tenant has that, and they get to keep that until the end of their lease. So you're always buying subject to a lease. And in fact, even in foreclosure, under the Florida Protecting Tenants in Foreclosure Act, it states that in a mortgage foreclosure, any lease that predated the mortgage foreclosure, not predated the mortgage, but predated the lawsuit, must be honored. So the tenant does get to live out their lease, even if it's been foreclosed and somebody has bought the property at auction. Now, is that ever likely to be the case? No, because foreclosures typically take a lot longer than a year, and most leases are a year. So you're not going to see it very often, but it's worth noting that even a foreclosure doesn't terminate a lease that existed before that. Can a landlord refuse payment? A landlord can demand payment in certified funds, but a landlord cannot demand full payment, refuse full payment. So if you give a 3-day notice asking for $1,000 and the tenant shows up with $1,000, you have to accept it. So there may be other things you can do to get rid of a bad tenant, but tender a full payment is compliance. And
The next question I see is, must landlord have a separate escrow account for each property, or can it be put into account for numerous properties as long as it is refunded at the end?
All right, so this is something very interesting. Florida statutes 8349 goes on at great length about handling security deposits. It even has a letter you're supposed to issue as the landlord informing the tenant where the deposit is being held and what all their rights are, what all their rights are. So here's the weird part. There's no penalty for not following that statute. So I would say as a practical matter, it doesn't matter what you do with the deposit. So yeah, the statute says what you should be doing with it. They should be in escrow, but since there's no penalty, I don't think it makes any difference. So having done this for a few decades, I've only seen one court decision where the landlord got busted regarding the security deposit. And this is a landlord that really pissed off the judge. So this landlord was in foreclosure. They were collecting rent and not paying the mortgage. The landlord then lost the property, continued to accept rent even post sale date. And when the house was foreclosed, he came in and stole the appliances. And that pissed off the judge so much that when the tenant pointed out that the security deposit had never been placed in escrow and that the landlord had kept it, the judge just lost it and said, okay, I consider that to be civil theft, which is triple damages. But other than that, which I think is about as extreme as you could envision, that you not only did you steal the rent and not pay your mortgage, but you took the appliances, and then it was your goal all along to keep the deposit. That was just more than the judge could tolerate. But otherwise, I think you're pretty safe doing whatever you want with the deposit. Now, of course, it's still legally the tenant's money. So if you don't establish your legal right to keep it, then you can be sued and pay attorney's fees for wrongfully retaining the deposit. And don't forget, landlords, you have real estate that is attachable by judgments. So anyone that sues a landlord and gets a judgment, that money judgment is a lien on the property, a lien that can be foreclosed, and a lien that Wendy will tell you will certainly prevent you from refinancing or selling. So landlords are going to pay their judgments because they are stuck. Now, suing tenants, good luck. I mean, what do they have to take? They don't own real estate. So in general, suing people without easily attachable assets is a fruitless endeavor.
And the next question, I think you actually addressed in the last session, says there was a change in laws to optional delivery of notices that if agreed to in writing overrides the certified mail requirements, tenants and landlords can give their notices by email.
Absolutely. And so that did pass into law, not effective last year. So that is a separate document signed by the landlord and the tenant saying that they agreed to exchange notices by email. I have never seen anyone do it so far, but yes, you can do that. And I find that having to send a certified letter is not very convenient. So I would encourage landlords to do the electronic delivery addendum. So you don't have to go to the post office and wait in line to send a certified letter. But yes, that is true. You can do a waiver.
Okay, and then somebody said, as far as withholding security deposit, don't they have to return the property in the same condition they got it? Not how do we word that for the fee?
No. Reasonable wear and tear accepted. So 1 year of wear and tear is a little, 10 years of wear and tear is a lot. So it's reasonable in light of the passage of time.
Okay, are we able to add addendums to an annual lease?
You can't change a lease that's already in effect. Just like a real estate purchase and sale agreement. Once it's signed, that's the deal. So to make a change, you need both parties to come to an agreement to change it. So you cannot unilaterally change a contract that's been signed.
Okay, how about damage to walls and baseboards when tenant moves out? Can you charge for that?
Again, the standard is reasonable wear and tear in light of the passage of time.
Okay, as far as adding fees, where do we write that on?
Anywhere you want, but fees don't happen by themselves, so you have to put it on the lease someplace. But bear in mind, fees are the landlord's money, period. That's not disputable. Deposits are the tenant's money until the landlord shows they're entitled to it. So whenever possible, charge a fee and not a deposit.
Okay, is there a lease extension form and where can it be found?
Well, all the forms that I've discussed, you can find on my website, browardlandlord.com. There's a page, free forms, and they're all PDF files, and then there's instructions on how to use them.
Now you have great links. It's awesome. I'll include all your links also in the follow-up with the recording. Somebody said used to be if lease date ends, it automatically goes month to month, not
No,
trespassing.
no, you're automatically a trespasser. Now, people put things in the lease themselves that's not part of Florida law. And so a lease might say, because you put it there, that it becomes month to month. But I will say something, which is that if you had an annual lease that ended April 30th, and then the tenant didn't move out, and you get a check for May's rent and you accept it, by accepting a check for 1 month's rent, you have created a new tenancy, which is an oral month-to-month tenancy. So there's a little bit of a gray area here, which is when you go from an annual tenancy to an oral tenancy, do any of the lease terms still continue, like late fees? So I think that's a little bit of a gray area, whether you're oral under the same terms or you've erased all the lease terms and now you're strictly under the statutory terms, which means no late fees.
You answered the next question. If a lease ends but landlord takes payment, it's now month to month.
Yes.
Okay. When a tenant comes in, emotional support or service animals must be accepted without charging a pet fee to the tenant.
Subject to verification. So that's the doctor letter or the other items that they have some sort of government documentation that they're officially disabled. But mostly what you have is a letter from a doctor saying, Alex Johnson gets comfort from his dog, so it's an emotional support animal. So
Okay,
it's pretty loose, except it has to be a real doctor that did see me in person.
Okay. Somebody said, I thought 2 years ago there was a lawsuit regarding excessive application fees that had to be reasonable, commensurate with time involved in Miami-Dade County.
Well, I don't know, but there's nothing to that extent in the landlord-tenant statute. And as you know, after COVID, the state of Florida preempted landlord-tenant to the state, meaning there are no longer any city or county landlord-tenant rules. They are all wiped out.
Okay, what is the required paperwork that we can ask for ESA or service animals?
Yes, so you can say, I need you to document your need for the animal. You can't cross-examine it. So if they have something from a doctor, preferably a Florida doctor, but if not, a doctor that can attest that they've physically seen the person, then that's pretty much game over. I was telling Wendy before we started, I had a case where the tenant had a doctor from New Mexico, and I Googled him, and this doctor was known as a sort of a pill mill of cranking out these letters as a little home business. So I told the landlord, this doctor's letter has zero credibility. But in
Okay,
general, you have to be pretty cautious about refusing a doctor letter.
can you charge an extra security deposit for ESA?
No, that's a disability situation. So if you have a disability, that's discrimination, not to accommodate the disability.
If a tenant used an internet letter to lease prior to the law changing, won't they now need to provide a new letter in accordance with the law?
Well, the statute said that anything from the internet is pretty much garbage. So really what it comes down to is the doctor letter.
Landlord have received letter from a therapist that looks like online or internet documents. In that event, can a landlord ask for a doctor document from a doctor that they have seen the tenant in person?
Yes, so the statute states that this doctor must have physically treated the patient face to face.
Okay, so I don't,
I left off that under the Florida law, there's a penalty for providing false ESA information. So it could come back to bite you if, as a tenant, you're submitting these fake internet documents. So it is a misdemeanor.
please clarify when a landlord can deny a service or ESA. Is it any property that is not considered commercial, i.e. over 4 units?
Again, if they've got a letter from a doctor that says they treated him, I think that you're stuck.
Okay. Does a non-functioning AC constitute a non-habitable unit?
It's a finding of fact. It's interesting because in the landlord-tenant statute, providing heat is in the building code, but providing air conditioning is not. You would think in Florida it would be the opposite, but
Yes.
so it's going to be up to the judge, a coin toss.
Okay, again, if a landlord owns 4 units or less, do they have to accept the service or emotional dog?
No,
Okay, in Broward County, we have a disclosure requirement to send or post at tenant door before charging late fees. There is a problem with that. What you have seen done about, there is a lot of problem with that. What have you seen done about it? By the time the late fee is due, there's not enough time to post this notice before the late fee ID is due. What should a landlord do?
okay, so that's a good question. And here's something that comes up is when there is a grace period, it could go one of two ways. Either the grace period is how long until you get a late fee, or the grace period is when the rent is due. So for purpose of argument, let's say the rent is due on the first of the month. Then you have a 5-day grace. So is the rent late on the 2nd, or is the rent not late until the 6th? That depends on the specific wording. So sometimes the grace period means the rent isn't actually due for an extra 5 days, in which case you can't issue a 3-day notice until 6 days late. Or the late fee doesn't accrue until 5 days late, in which case the rent is late on the 2nd and you can give the 3-day notice on the 2nd. And then after the 5 days, then you have a late fee on top of that. So look at your lease. I've seen it go both ways. But it does make a big difference because if your 3-day notice was issued prematurely, you don't have the right to file the case. So if you did file your case based on a faulty 3-day notice, you're going to lose.
Okay, I think this, I don't know, I saw this question before, but I guess you put it in again. Lease started 2/1. Rent is $3,100 a month. Tenant paid first last month to move in and agreed to pay $600 extra every month until July to pay off all the last $700. Now the tenant wants to move out by the end of May, asking the landlord to allow her to pay the rest of the deposit after. Most of the deposit. After move out. Lease states for early termination, tenant needs to pay 2 months. Can the landlord refuse and demand her to pay all the balance or evict her? Everything was on the lease. Reason for tenant leaving is because a random event in the neighborhood. There's nothing the landlord can do.
Okay, so when you break the lease, you're either liable for all the rest of the rent or with early termination, 2 months rent. So if the tenant is terminating early, they owe the rent for all the months in which they were at the property, plus 2 extra months. So that's the end of that. If they had prepaid last, then that would be one of the months, so they would owe the other month. As far as security, that's still the tenant's money, so it's sort of pointless to be paying security after you've already left, because you're not committing any damage.
Okay, I have my own extension of lease form. Can I use that? And sometimes I write a new rent increase or just go month to month.
Well, this is my personal preference. I prefer month to month because when you have a pain in the butt tenant, uh, you need to have them in breach of contract to kick them out. And if you're going to do that by a 7-day notice to cure, then you have to prove in court that they did whatever it was that's annoying you, like the wild parties or clogging the toilet or breaking windows. But if you have an unpleasant tenant that's month to month, you just give them a 30-day notice and then that's the end of the tenancy. There's nothing to prove in court. So I personally like month to month as something to protect the landlord. You may not be allowed to do that because of HOA restrictions or Section 8. But in my opinion, if you can do month to month, you should. Moving is expensive and annoying, so I don't think that tenants just move on a whim. So I don't believe the end date of the lease binds the tenant at all. If they're going to move, they're going to move. And usually they're going to warn you of their intention to move by not paying rent anymore. So I don't think they care how long the lease is. They're just going to go when they feel like it. But they're not going to leave for no reason and pay for a move and go through all that disruption. So that's my personal opinion that I like month to month.
So somebody said, I asked about the 7-day notice, landlord inherited tenant stating they need a screen door, does not specifically addressed on lease, nor an estoppel letter sent to the tenant before the new landlord bought the unit. Now tenant stating the new landlord is in breach of contract. The unit came without a screen door. What does the landlord must do in this case?
Interesting. So the statute actually addresses screens, and it states the tenant is entitled to screens at the beginning of the lease. So I guess if there was no screens at the beginning of the lease, then that's the way they started. But they're not entitled to replacement screens. So I think that this tenant doesn't have any kind of a case about a missing screen. The other
Okay.
thing is that you'd have to be sort of crazy to go on rent strike because of a screen and then get yourself evicted and then have to fight it out in court. And now you have an eviction on your record. So, I mean, the worst case scenario is the judge goes, okay, no screen door, landlord put a screen door in. Now you have the eviction and what did you get out of it?
So then why have a statute if there's no punishment?
I agree.
Hope you can speak about Section 8.
Aha.
I told you that was coming up.
You did. Okay, so a couple of comments about Section 8, and of course, I'm only addressing this as a landlord-tenant attorney, that there is really nothing in the area of landlord-tenant changed by Section 8, except that if you're going to do an eviction, you have to notify Section 8 that you're evicting their tenant. The other thing is Broward County has an ordinance stating it is unlawful to deny a rental application because the tenant has Section 8 funding. So that's under the Broward Human Rights Ordinance. So if as a realtor you advertise we don't take Section 8, you are going to get sued. I don't know how much you'll have to pay, but there are lawyers floating around out there just looking for a chance for an easy score. And you've handed it to them by saying, I discriminate. So as you know, as a realtor, you don't ever advertise that you discriminate.
Is it a good idea to have the owner accept Zelle from the beginning of the lease? What happens when an eviction comes up?
I personally love Zelle because it's non-refundable and non-revocable. So yeah, go for it.
When a new property changes ownership, is it legal for the new owner to require a new lease agreement with a different expiration date?
Yes,
Or, okay, you like Zelle, so you think it's great, so okay, we got that.
right. But it does bring up an issue, which is that once you've filed the eviction, you can't accept any rent payments without waiving your cause of action. So the Zelle issue is that the tenant didn't pay his $1,000 May rent. You file the lawsuit, they Zelle you $100. So now that's not the rent, but you received the money, but you don't want it. You do have the right to refuse it, but there's no way to refuse a Zelle payment.
Hmm.
So then what you have to do is is write up a money order and drive to the courthouse and deposit the $100 with the court registry.
So
So
that sounds complicated.
Zelle doesn't have refunds, so you can't kick it back. So now you got to put the money in the court registry.
What if there is a broken tile and there is no extra tile to replace it? How do you charge the tenant for that?
Well, I again, this is all going to be what the judge feels like doing, and everyone has to be aware when you're in a courtroom. There's no predicting for sure what the judge is going to rule. So it's always a crapshoot. So, from what I've seen with insurance claims, if you've got a broken tile and you can't match it, then you're going to have to retile everything.
Wow. Okay, non-refundable pet fee plus pet rent, presumably legal.
All fees are legal.
Please explain the importance of asking tenants to purchase renter's insurance.
Well, it's always nice to have another insurance company to help pay for things, but the landlord's insurance policy doesn't insure any personal property. So if you have a flood, which we've had a lot of freak floods over the years here in Fort Lauderdale, if their stuff is destroyed, then there's no insurance for it. The landlord's insurance doesn't cover personal property. So that's really for the tenant's best interest. Of course, if the tenant has a dog and it bites somebody, you want the claim to go on the tenant's insurance, not on your insurance. So, and again, I've seen that the landlords will put an insurance clause in the lease and then they don't enforce it. So you should require liability insurance for your tenant, but then remember to follow up and say,
Hmm.
okay, you've moved in, where's your insurance? And if they don't have it, then give them a 7-day notice because let's say they have a guest over and they fall down the stairs, then they're going to sue the landlord.
Okay, can we hold late fees from security deposit at move out?
Yes.
Your suggestion for renewal is to do an addendum.
Well, I think it's debatable whether once you go month to month after a lease, whether all the lease terms carry forward. So the best would be either to sign a new lease or just do an addendum regarding those issues. I'll point out that on my website is a lease that anyone is free to download, and it's a little bit creative in that the lease is month to month, although it doesn't look like it is. And it only addresses the things that are not already provided by law. So in Florida, the landlord-tenant statute states you are not allowed to do anything contrary to the landlord-tenant statute. So whether it's in writing or whether it's not in writing, you still have to follow the statute. So if you look at a FAR lease, that's pretty much the statute right there. So that's the invisible lease. So all the other things like late fees and penalties and redecorating, that's the lease I have on my website. So if you finish up with your annual lease, feel free to download the lease on my site, which is a month-to-month lease with all the punishments in it. So
Awesome.
it's very one-sided. It's completely pro-landlord. So here's something interesting to note. What is the difference between an annual lease and a month-to-month lease? It's one thing, an end date.
Ah,
So if it says the rent's 1,000 a month, that's month to month. If it says it's 1,000 a month and it ends June 30th, then it's a fixed term lease. So my lease is like that, but it doesn't have an end date. It has a start date, but if it doesn't have an end date, it's month to month. So for me, a lot of times my tenants think that they've signed a 1-year lease. And that's fine because hopefully that encourages them to stay for a year. And they've even called me up at the end of the year saying, hey, it's anniversary time. I need to sign a new lease. So I'm like, fine. I mean, they were month to month anyway, but if they want to sign another lease, great, we'll do it. So
okay. If
normally
an
they don't
owner,
really pay attention to the lease until something is
no,
wrong. And then
that's good
they
to
read it and
know.
they're like, oh shit,
No.
uh, I didn't know that it said that. And I don't get away with it by really small print or that. It's 12 point.
If an owner wants to sell before the lease expires, can the owner still sell with giving notice to the tenant?
Again, you're selling subject to the lease, whether you like it or not. So yes, if if you're doing things right, Wendy is going to send out a tenant estoppel letter to all the tenants, asking
Yeah,
them to verify the lease terms and how much deposit is in escrow and what the rent is, so she can properly credit the buyer.
absolutely.
But so it's good practice that the tenant is aware that it's selling, but there's nothing the seller can do about terminating the tenancy. The buyer is going to take subject to your lease.
What about people who have to move because of circumstances? Then doesn't landlord have a duty to try and rent versus collect either 2 months or entire lease?
Not unless you're active duty military. If active duty military is transferred, then they get out of their lease. But
Well,
otherwise, no, too bad.
what will be your advice on a lease renewal, right? Again, the contract to lease and lease agreement or an addendum?
I personally hate a contract to enter into a contract. So just do the contract. Uh, so my preference would be the lease I have for free on my website. But there's no problem having no lease at all because you still have the FAR bar lease, the invisible lease with all those terms. Except don't forget, it doesn't include any late fees or any kind of decorating fees. It's just all the other rules.
Okay. If your lease is less than 6 months, there are many taxes that need to be paid, including a tourist tax.
No, the state of Florida canceled sales tax on leases. So there is no longer a sales tax on a lease. I'm not that familiar with Airbnb and if that's under some sort of special taxing, but there are no rent taxes anymore.
Because somebody said, I like month to month, but rent subject to sales tax if under 7 months, you say no, right?
Yeah, the state of Florida has abolished sales tax on rentals, commercial and residential.
Okay, what if you lease to Section 8? What if Section 8 pays and tenants don't?
That's up to you. If the tenant owes you even $1 of rent, they're still in violation. I've had evictions similar to that where we were evicting for less than $100. But if you issued the 3-day notice and they didn't pay it, that they terminated their tenancy. Uh, so it's really an economic call. Is it really worth kicking out the tenant that's getting the vast majority of the rent wire transferred to you each month? So that's up to you. It's a business decision. But legally, if they're not paying rent, you can evict them for it.
Okay, there's still a lot of questions. If there is no penalty in the lease agreement for terminating it before the expiration date, how does it affect a tenant who moves out before the lease ends?
Uh, when the tenant leaves prematurely and there's no early termination agreement, the landlord has a choice of 3 courses of action. So they can do either of these 3 things at their own discretion. One is say, fine, you're gone, the lease is over. Adios. Two, I'm gonna try to re-rent it, and when I get a new tenant, then you don't owe that rent that somebody else is paying for you. All right, so yes, legally, once you do get a new tenant, you cannot double dip. So if you moved out on me and the rent's 1,000 and the tenant moves in June and get me my 1,000, the old guy doesn't owe me any money anymore, just the May rent. And then the third is, I don't care, you sign a contract for a year and I will wait for the whole year to be up and sue you for all 12 months of rent. So there is surprisingly no duty to mitigate, meaning you should try to get a new tenant. Now, is that smart to do that? No, it is not smart to sit back and collect no rent. And you could have, because like I said, suing tenants is mostly pointless. So, and I don't see why you would just say, fine, you don't owe me any money. So it's normally going to be the middle course. You owe me the money I should have been getting that I didn't get. But once I get money from somebody else, you're off the hook.
Okay, somebody wants you to please clarify again, if an owner owns 4 or less units, can he reject ESA?
That's what it says. Not service animals, but the support animal.
Okay, somebody wants your contact information. I'm gonna send it when I send a copy of the recording, but I'll put it in the chat right now as well. Bless you.
Claudia is a cold.
Sorry, I didn't know I wasn't on mute.
Oh, that's okay.
Sorry.
It's all right. Bless you. Somebody said, I've seen denial of any damage from landlord insurance company because of tenant's negligence and landlord wasn't living in unit. I don't know, is that a question?
I'm not sure, but I'll just make a quick comment that it's very important that you have the right kind of insurance. So if it's owner occupied, then you want the regular full insurance. If it's landlord, you have a landlord policy that insures the fixtures, but none of the personal property. And then as a tenant, you have the opposite. You're only insuring your personal property, but no fixtures. So if you have the wrong policy, you're just wasting your money because they'll take your payments, but when it's pay out time, they'll deny your claim. And if you have any questions, talk to your insurance agent, but don't lie to them because when it's time for the insurance company to write a check and something's wrong, you're not going to get any money.
So regarding the insurance, can they have the landlord listed as additional interest so the landlord can be informed if policy lapses?
Good idea.
What about taxes? You already answered that about taxes, that there are no taxes, right?
Right. I'll just throw in something on the subject of homestead. Obviously, the very great protections that we enjoy in Florida for homestead is for owner-occupied property. There are very small exceptions for renting, which is you can rent for, I think, 30 days once every couple of years and not lose your homestead, or you can rent a minority proportion of your unit and get your homestead only reduced by that proportion. But in general, the property appraiser is looking to revoke your homestead if you're renting. So normally I would say it doesn't make economic sense to rent any portion of your homestead or Airbnb or anything, because if they can revoke your homestead, they'll do it.
Right.
And if you've lived in the place for a while, your benefit has been accumulating because you've got that 3% cap on your tax assessed value. So over a period of time, you're being assessed at maybe a fraction of its current market value. And if you're caught renting, that whole thing just evaporates. And that savings that you have is portable, meaning if you sell that property, you can take the savings along with you to the next house. And to blow it is a tragedy. So don't play games with your homestead.
No, but there's no taxes. There's no tourist tax or rental tax on rentals.
No. Now,
Okay,
again, that's said without any knowledge of Airbnb.
right.
So regular rental, there's no tax.
Okay. If damage is
Now,
found after, oh, sorry.
there's one thing, which is that the cities have been getting more and more into charging license fees for rentals. So
Hmm.
there's not an official tax like a sales tax, but a lot of cities are making you get a license and pay for an annual inspection, which is sort of a tax.
Okay. If damage is found after move out and there's a renter's policy in place with landlord as additional insured, can the owner file a claim for damages?
Again, that's apples and oranges. This the tenant's policy only insures the tenant's personal effects. The landlord's policy insures the landlord's property. So they're insuring two separate things.
So the tenant's policy is just walls in.
Well, it doesn't do the landlord any good because it doesn't insure fixtures.
Okay, that makes sense. If duplex owner stays on one side and renting out the other side, how do you handle that?
Well, at the best, you're going to get half of your homestead, and at worst, you're going to get no homestead.
Okay. Who's responsible if the tenant's animal bites a neighbor? Would tenant's renter's policy cover that, or would landlord remain liable?
So the liability for dog bites, of course, the whoever gets bit is going to sue the landlord. I think that at the end of the day, it's going to be based on negligence, meaning if the landlord had some sort of awareness of the animal's dangerous tendencies, then the landlord could be held liable. But if it's a first bite situation, the landlord is probably not responsible. So again, for you to owe people money, you have to have done something wrong.
Okay, and now Vivian's saying there is a tourist tax in Florida, yes, but it doesn't apply to rentals, correct? Only maybe Airbnbs or hotels.
Well, hotels are a completely separate animal.
But
Uh,
it doesn't apply to rentals, just maybe Airbnbs.
right. And I'm not even sure that Airbnb people pay anything like a hotel tax or a tourist tax.
Because they're
I
going
think,
to pay a
in my
licensing.
opinion, I think they probably should because they're really businesses, but they're sort of treated as if the same as a regular rental.
Okay. What's the best way for a tenant to write in the lease the possibility they will have to move before the end of the year?
Well, you could put a clause in the lease that even though it's a one-year lease, that either party could terminate based on X amount of notice. I mean, if it's 30 days notice, it's the same as a month-to-month lease. So maybe 60 days notice. But yeah, you could put that in the lease.
Okay, so
You also could put in, if you want to terminate early, an early termination fee of 1 month or 2 months rent.
there are several, then Vivian's saying again, there are several taxes they own if they own, I don't know, RV lots. I don't know if that's anything different.
RVs, mobile homes is an entirely separate statute, which I'm not familiar with.
Okay, so that's totally different. That's why there might be taxes. Okay, well, you've answered all the questions
Wow.
and we had a lot of questions. We've gone a little late because we knew there was going to be a lot of questions. So very hot topic, awesome session. I will send out a copy of the recording and I've also put Alexander Johnson's information in the chat and I will add it again once I send my information. So if you guys have any further questions, you have the contact for Alexander Johnson. You can reach out to him. You can go on his website and use all his amazing resources. And we'll circle back in another couple months and we'll do another class. So I know it's a hot topic and there's always something new and great. Thank you so much, Alexander Johnson, and thank you all for attending. And just remember, when you need a title company, please keep me in mind. Wendy Rosenberg, South Florida Title Associates, the Nob Hill branch. Really takes me a long time to put together all these training sessions and send you all the follow-up. So just show your appreciation and send me some of your closings. Like I say, I don't need all your business. Of course, I would love it all. Just think of me at least on the next deal, and I'd be super thankful. And I know that you and your clients will be happy as well. So stay safe, have a great day. And I've got another great, actually next week, I have 2 training classes. I don't usually like to do that, but somehow I got roped into it. I'm doing on Wednesday a Zoom on AI and closings. And Friday, I'm doing a lunch and learn at Total Wine and Plantation with Lee on all the latest updates in insurance. He just got back from Tallahassee and he's got a lot of insurance news for us. So mark your calendars. Wednesday, it's going to be at 1:30 Zoom, and Friday, it's going to be at 11 o'clock at Total Wine Plantation. All right, stay safe, and I will send out emails. Don't worry, you'll get links to register. Thank you all, and thank you, Alexander, and have a great rest of the week and stay safe. Okay, thank you all. Bye-bye.